In 1937, President Franklin Roosevelt infamously threatened packing the Supreme Court in order to have a court favorable towards his New Deal programs. In the end, it wasn't necessary. As appointments came open for Roosevelt, he filled them with activist progressive judges that were glad to rubber stamp his New Deal programs. By 1942, the court was 9 liberal progressive activist judges and no conservatives. I'm Ben Murray, director of the Fiscal Policy Center here at Independence Institute, and I'm back on this week with Rob Natelson. Rob and I have been speaking over the last couple weeks about his essay series, How the Supreme Court Rewrote the Constitution. This week, we're going to delve into the cases and the decisions made by the Supreme Court that expanded the federal government's role in our economy. Rob is the senior fellow in constitutional jurisprudence here at the Institute and also leads our constitutional studies program. Rob, thanks for joining us today.
Great to be back with you.
Rob, you set the stage last week in the 1930s. You talked about Roosevelt being elected in 1932 and how at that time you really began to see these drastic changes in how the Supreme Court interpreted the Constitution, how the Supreme Court, as you say, rewrote the Constitution. Now, before we get into the specific cases that were crucial, that were important between, especially the 1937 and 1942 period, talk about these justices that were appointed by Roosevelt that you say really weren't qualified.
Well, I think most of them weren't qualified, at least not by traditional standards. Among all the justices he appointed, and I recall he appointed 9, only one of them had any significant judicial experience. That was Justice Wiley Rutledge. And he had 4 years of experience on the Court of Appeals only because Roosevelt had appointed him to the Court of Appeals 4 years before because of his loyalty to the New Deal. Essentially, that seems to have been Roosevelt's criterion. Now, some of these judges turned out to be superior jurists, Felix Frankfurter, for example. But these are judges who, because they do not have prior judicial experience, they're not really subject to the traditional ethos that bound judges. And so they would go off on their own adventures, and that's what, in fact, happened between 1937 and 1944. That's why the Constitution was so significantly rewritten.
I want to actually hop right into Article 1, which is where we see a lot. Obviously, that's where the Constitution grants power to the Congress, and where we see a lot of this rewriting happen during these years. So let's just jump right into it and start to talk about your essay series where you actually go through specifically and name cases that were central in rewriting the Constitution.
Yes.
Why don't we just jump right into United States versus Butler and the General Welfare Clause?
Yeah. Now, the United States Constitution has a clause which is called the Taxation Clause. It gives power to Congress to tax. For those people who are wonks, you can find it at Article 1, Section 8, Clause 1. And it says specifically that Congress can tax for the general welfare. General welfare is designed to be a restriction on the power to tax. In founder speak, that meant that you can raise money for purposes that are general interest, like defense, for example, or the regulation of commerce, but you're not supposed to be able to tax for special interest purposes like paying Peter and robbing Paul in doing so. So what happened in the U.S. Against Butler case is the court dealt with the constitutionality of a New Deal agricultural program. And the court actually wound up striking down the program, but it handed the New Deal a victory by saying that this general welfare clause is not a limit on the taxing power. It is an authorization for Congress to spend on anything that Congress deems appropriate for the general welfare, essentially anything at all. The following year, in a case called Halvering versus Davis, the court took that comment, which arguably had been what we lawyers call dicta, that is unbinding side comments, and converted it into settled judicial precedent. So in Halvering versus Davis, the court says, again, 1937, the court says from now on, Congress can spend whatever it wants, right? And we see the results today, don't we? With a national debt that keeps rising, with a Congress that simply can't balance its budget, and with enormous interplay and conflict among special interests, all seeking federal money.
When I hear you talk about the general welfare, or I just hear general welfare clause, I mean, that actually does sound pretty broad to me. What you're saying is they've interpreted this too broadly.
But they didn't interpret it too broadly. They interpreted it differently. They interpreted it as a authorization for spending instead of a limitation on taxes.
I see.
It was very common in founding era literature to say that government must serve the general welfare as opposed to what they would have called partial interests or special interests.
For our audience, can I read this clause real quick so people have it in their head? The Congress shall have power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excises shall be uniform throughout the United States to borrow money on the credit of the United States. And then we go into the Commerce Clause.
Yeah, and there actually are two limitations on that. There's a general welfare limitation, and there's also, right in the same clause, a uniformity limitation for what the founders called indirect taxes. When the court issued this decision, it didn't consult the founding era record at all, except for the writings of two people, James Madison and Alexander Hamilton. And Hamilton had said that this is a limitation on taxation. The article that the paper of Hamilton's that the court consulted was a paper written after the Constitution was written, contradicted what Hamilton had said before the Constitution was written, and contradicted what just about every other leading advocate of the Constitution had said. The court didn't bother to examine any of that.
And yet this is what the court largely relied on.
Was Alexander Hamilton's comment.
Interesting.
His comment, which was an effort to defend a spending program he had when he was Secretary of the Treasury. But again, they ignored all the rest of the founding era record. So that is how the spending power was changed by the court. Arguably the first clause rewritten by the court in this period.
So that's pretty big, and you gave us some of the practical implications of that a moment ago. Let's hop into the Commerce Clause, because
yes.
If I would have kept reading, we would have hit the Commerce Clause.
Go ahead.
So you have the next section of the Constitution: to regulate commerce with foreign nations and among the several states and with the Indian tribes. The Commerce Clause is notorious in limited government circles, let's say, for being the clause that's been way too broadly interpreted, giving Congress way more power than what the Constitution originally was intended to give them. What authority does the Commerce Clause give Congress?
Okay, well, let me just say, talk at the outcome first, okay? Just as this rewriting of the spending power created a situation where Congress can spend anything it wants, so this rewriting of the commerce power creates a situation where Congress can regulate any economic activity and even some non-economic activities, as we've seen in a case that just came down a few days ago from the Supreme Court. Now, when the founders wrote the phrase, Congress shall have the power to regulate commerce among the several states, commerce had a very specific meaning. It was a body of law called the law merchant. The law merchant was a body of law that applied, as the name indicates, among merchants. And it also included some things that you might not think of as among merchants necessarily, such as navigation. Control of navigation was given to Congress by the Commerce Clause. So it has this specialized meaning. It entitles Congress to regulate one portion of the economy, mercantile trade, but not other portions of the economy. So if a merchant in North Carolina is selling shoes to a merchant in New York, that under the Commerce Clause, properly construed, can be regulated by Congress. If, on the other hand, there is a manufacturing plant in New York or a shoe store in New York that does business only in New York, those are outside the Commerce Clause. It was a deliberate attempt by the framers to take responsibility for regulation of the economy and split it between Congress on the one side and the states on the other. But the outcome of the way the court changed the Commerce Clause is to give ultimate power over the entire economy to Congress. But there's another piece to this puzzle, and this is a good time to bring it in. The Constitution also includes a clause called the Necessary and Proper Clause,
Yep.
Article 1, Section 8, Clause 18. And it says Congress shall have the power to make all laws which shall be necessary and proper for carrying out the foregoing powers and certain other powers. The Necessary and Proper Clause does give Congress some ancillary authority, some subordinate authority over non-commercial activities if exercising authority over those non-commercial activities is reasonably necessary or customary in regulating commerce. I'll give you a very, very simple example. Let's suppose that Congress decides to regulate the interstate shipment of pharmaceuticals, let's say. Congress could, under the Necessary and Proper Clause, dictate that the labels on any pharmaceuticals that are going to be sent across state lines meet certain criteria. The ingredients, maybe the dosage, the indications for the use of the pharmaceutical, and so forth. Now, passing a law mandating labeling is not, by a very strict definition, it's not regulating commerce. It's regulating packaging or regulating manufacturing, right?
Right.
But that is an ancillary kind. That's the ancillary kind of activity, or subordinate, or the legal term is incidental kind of activity that is authorized under the Necessary and Proper Clause. But that activity has to be truly connected to the commerce in some way and subordinate to the commerce in some way. And there's a whole body of 18th century law on that subject.
So to understand what you're saying, hypothetically, we're here in Colorado. If there were a pharmaceutical company that developed a drug right here in Colorado, and then they wanted to sell it at my local pharmacy, straight to me, developed it here, they manufactured it here, and they wanted to sell it to me here at a CVS. Hypothetically, if that were to happen, Congress has no power there to regulate. The FDA has no power there to regulate.
Well, Congress would have power to specify the patent, the criteria for the patent under which the drug was patented, right? Because of another clause called the Intellectual Property Clause. But putting that aside, you're right. If the drug is totally manufactured in Colorado, sold only in Colorado, under the original meaning of the Constitution, the Commerce Clause does not reach that. So does that mean the drug is completely unregulated? Of course not.
The state would regulate it.
The state would regulate it, and the states were seen as the primary protectors for health and human safety when the Constitution was written.
Today, it's hard to imagine a world in which the FDA wouldn't be involved there. You know,
that's right.
Let's talk about some of these cases. So we get into the Commerce Clause, and the Jones and Laughlin case. I mean, I haven't been to law school, and I've heard of this case.
Yes.
It's sort of notorious. Let's talk about that.
The Jones and Laughlin case dealt with the question of whether the federal government could regulate the labor relations in a multi-state steel concern, right? It was a very, very large company, did business, I think, in something like 11 different states. Could Congress regulate that, labor relations? The opinion was written by Chief Justice Charles Evans Hughes, who I mentioned last time was trying to seek a balance between the traditional rules of constitutional construction and the needs of the New Deal. And in his opinion, he basically, although he doesn't say so, relies on the Necessary and Proper Clause. He says that this is such a large concern that the elements of the concern are so, interstate elements of the concern are so tightly woven together that it's really appropriate under the Necessary and Proper Clause for Congress to regulate, and therefore he upholds the use of federal labor law. Now, let me tell you what the problem with that decision is. The
Please.
problem with that decision is the Necessary and Proper Clause is designed to reach only ancillary types of activities, not a whole. You know, labor relations is a separate category, a very important separate category, separate from commerce. And so he stretches the Necessary and Proper Clause. And I think he was trying to find a stable solution or a stable compromise, but it didn't hold long.
And he kind of opened the floodgates to cases that came after that.
That's what I mean. It didn't hold long because in 1941 in United States versus Darby, the court applied the Necessary and Proper Clause to a small concern. And then in the following year in Wickard versus Filbert, it applied the necessary and proper clause to a small family farmer who violated government wheat limitation restrictions by raising wheat on his own farm and consuming it on his own farm and not setting it into commerce at all. And so this attempt by Charles Evans Hughes to maybe do just a little bit of constitutional damage quickly collapsed with his successors on the court. And today virtually any activity, the formula that the court follows is any activity with a substantial effect on interstate commerce. But as a practical matter, almost any economic activity is now regulated under the Commerce Clause. And just the other day, the court issued an opinion in a case called Holland versus Brackeen, in which the court said even non-economic activity, if it involves the Indian tribes, could be regulated under the interstate commerce, under the Commerce Clause. So you can see where we are now.
You know, when I came across that example you gave of the case with the wheat grower who wanted to grow wheat for his own home consumption, and the justice said something to the effect of, well, if a lot of people were doing this all over the country, it would have an impact on the broader economy and on commerce.
That's called the aggregation rule. You yourself may not have a substantial effect on interstate commerce, but other people who do the same thing, everybody in the class has a substantial effect on economic activity or on interstate commerce. And of course, you can draw the class however you want to bring in almost anything. In a case called Gonzalez versus Raich in 2005, the U.S. Supreme Court said window box growing of marijuana, literally growing marijuana in your window box, sufficiently affected interstate commerce to be regulated by the federal government. So it's become somewhat of a joke. Let me just say that the justice who wrote Wickard versus Filburn, which was decided in 1942, Robert Jackson, he had been Roosevelt's attorney general. You know, he's Roosevelt's man. Roosevelt puts him on the court. Documents that have come to light show that even he had some real doubt, should we really do this? Wow. I mean, isn't this really going too far? Wow. But ultimately, he buried those doubts and wrote a decision turning the entire economy over to the federal government.
Wow. So, Rob, that kind of brings us right back around to another case with the Commerce Clause. You mentioned it at the end of one of your essays here, United States versus Southeastern Underwriters Association, where the court took this even a step further.
Yes. This was a Hugo Black opinion, and in my opinion, it rates as one of the court's most dishonest decisions. The question was, may Congress regulate insurance using the Commerce Clause alone, not the Necessary and Proper Clause? Is insurance commerce? Now, the Supreme Court had already held several times that insurance, except for cargo insurance, which is used in the course of commerce, that insurance other than cargo insurance is not commerce. It already ruled that several times. Nevertheless, the court overrules its prior decisions on the matter and decides that insurance is commerce. And Justice Black cites several alleged sources. He says, for example, all the dictionaries and encyclopedias and law books of the founding era say that insurance is commerce. He doesn't cite any of them, and I will tell you why, because there are none. It was just a lie, frankly. And then he relies upon a book written by a disaffected law professor who had worked for the Roosevelt administration, which claimed that all economic activity is commerce. Again, very, very thinly supported book. So Black wrote as if this were accepted doctrine at the founding era, and it simply was not. And there wasn't, unlike in the Butler case, which expanded the spending power, where at least they quoted Alexander Hamilton, no founding era record was cited here, I will say, except for one article by Alexander Hamilton. But Alexander Hamilton was referring specifically to cargo insurance.
Sounds like maybe we can blame all of this on Alexander Hamilton.
Well, you know, even Hamilton recognized more limits on the federal government than the New Deal Supreme Court did. And again, I call this a mendacious decision because here Hamilton is talking about cargo insurance, which of course was understood as being governable under the commerce power, and Black, on the other hand, is applying it to all kinds of insurance. So the decision was not an honest one.
Before we wrap up, I want you to talk to just the regular person who lives in the United States today. Why should they care about all this? I mean, what are some of the things that are affecting their lives because of these decisions we've talked about today?
You know, eggs now are, over $3 a dozen?
They were at $6 at one point.
Yeah, there were $6 at one point. And you know why? They're there because the Supreme Court lifted the limit on the spending power. The federal government, both under the Trump administration and the Biden administration, in responding to the COVID epidemic, simply spent money on all sorts of things it didn't need to spend money on, and that triggered inflation. That's one reason you should care. Another reason you should care is the debt that we're leaving those who come later. And frankly, the strength of the United States today, even with a debt that exceeds the size of the economy. You also should care if you want to choose if you want to choose the kind of education you want to choose, or you want you want to buy the kind of product you wish to purchase, because the federal government uses its spending power and its expanded commerce power to limit your choices in all sorts of ways. I mentioned in the earlier interview that federal regulation was like air, and sometimes it's like poisonous vapor. It keeps us down in ways that we feel, but that we often don't feel.
So we've talked today about the economy, and these court decisions have had broad implications for the U.S. economy and how much of that's controlled by the federal government. What we haven't talked about, and we're going to talk about this in next week's final interview in this series, is civil liberties. So I want to have you back next week so we can talk about how civil liberties have been affected by the rewriting of the Constitution by the Supreme Court. But in the meantime, I want you to remind our viewers where they can see your materials and read more of your great work.
Sure. Go to independenceinstitute.org and click on the Constitution tab. And if you're interested in particular on how the Supreme Court rewrote the Constitution series, enter a keyword like rewrote, and scroll down a bit, and that series will come up. All 7 installments of the series combined into one article for your reading pleasure.
That sounds incredible. I think people will be really well served to read that. And I have read the whole series. It's excellent. You get a little bit condensed form in this video interview series that we're doing. Rob, thanks so much for being on.
Thank you for having me on.